Fredrickson here on behalf of Jeffrey Allen Grimes, the appellant in this matter, and I would like to reserve 7 minutes for rebuttal. It appears from the briefs that the appellee in this case has taken a little turn and has changed tack. They no longer argue that the court did not err in having a new trial. What they are saying, the thrust of their argument, is that it was this appeal is untimely because we did not file a notice of appeal within 30 days of the court's case management order that ordered that the case be set for trial within 120 days. And it's kind of semantics. There were several other orders that were entered thereafter relating to the trial itself, but really all of that, which would have been more than 30 days after our appeal, was 30 days after all of those orders. So they say that your appeal is untimely. And the basis for that is that generally a order granting a new trial under Rule 1.530 or even a rehearing under 1.540 would be reviewable as prescribed by 9.110 as a non-final interlocutory order subject to this court's review. The problem here is this was not a situation where we had a 1.530 motion. There was no motion for new trial. There was no motion for rehearing. There was later on in the case, but not as it related to this, not as it related to the vacating of the original result. Every case cited by the plaintiff, by the appellee in this case, is a traditional 1.530 motion, where there is a motion filed after whether or not it's a jury or a non-jury trial. The result is challenged by one of the parties, obviously the aggrieved party. That party then, the court makes a ruling, and then in that case, it would be the appellant, but the aggrieved party would then have to challenge and say, no, we want the original result of the trial. That didn't happen here. What happened here is we had original trial, appeal. A year and a half after appeal, we have a concession of error. The court then treats the concession of error after there was an unrelated stay for bankruptcy, but this court treats the concession of error as a motion to relinquish jurisdiction with very specific instructions. There was 3 specific things that the court could do. And at this time it was Judge Taylor. The court said that if the trial vacates if the trial court vacates the judgment, the appellant shall file a copy of the order vacating and notice of voluntary dismissal of the appeal, I guess. If the trial court declines to vacate the judgment, the appellee shall file a copy of that court's order stating so, in which case jurisdiction shall return to this court and the appeal shall proceed. The third thing is, if neither of those occur, then the appellee shall file a status report. So,
Mr. Fredrickson, let me get this. Yes, Mr. Fredrickson, before you leave the order of August 23rd, I have a procedural type question to ask.
Okay.
As I was working on your case, the concession of error said the trial court erred, and then it said it wanted a reversal. My concern is that the order of the court of August the 23rd is incorrect as a matter of law, and that the parties had an opportunity under Rule 9.330 to raise a motion for rehearing to let us know that the concession of error did not result in a simple reversal. It would result in an involuntary dismissal. And if that remand was not challenged, my question is your position then arguably waived?
Well,
and I hate to say that because the error seems to come from us, but we're looking at the remand, and the remand sends it back for jurisdictional purposes. And the argument that you are making now is the same that you would have made then. Insufficient evidence. We're entitled not just to a reversal, but we're entitled to say they don't get a second bite of the apple.
Right, Judge. But I think the distinction there is if I don't know if the court picked this up, but the Judge Taylor reversed, and I agree with you. She didn't finish the sentence, right? What she did was she asked this court.
I'm not worried so much about Judge Taylor. I'm concerned about our order. And there's a case out of the first on R.J. Reynolds Tobacco, 118 Southern 3rd, 844. And if our order is wrong in the remand, that was this, we're going to treat this as a relinquishment of jurisdiction. Do you need to file a motion of rehearing to correct us to say there is no remand necessary? You need, Judge, to decide the remedy based on their concession of error and no second bite of the apple. I'm concerned before we get to Judge Taylor, whether there's an error here that we made. Unfortunately, let's assume that hypothetically, I've been known to be wrong before. And if I'm correct, so I'm not asking you to concede that we made an error. I'm just saying, if we follow that down the road, then you had an opportunity to rehear, bring it to our attention, and it would never gone back to Judge Taylor.
I largely agree with what you're saying, with one critical distinction. I didn't know that's what was going to happen. Nobody knew that's what was going to happen. It was, I understand what the court's saying, but if I was objecting to something that I didn't know was going to happen at that point, there was even motions for attorney's fees filed. I know before you get back to Judge Taylor, I understand what the court's saying, perhaps, but I would have had, I believe that required the attorneys to read into it too far, to anticipate what Judge Taylor would have done and say, well, Judge Taylor's not going to vacate it. And instead, Judge Taylor's going to ask this court again for clarification. And to the extent that I guess I would take that down the road, is that's kind of what Judge Taylor did when we didn't necessarily call it an error, but Judge Taylor said, I'm confused on what you want me to do. And to us, there wasn't any confusion.
I can understand what people are saying. We're concerned about what the second district wants us to do. I understand. And I think I understand the position that you're advocating, and I don't want to take up all your time. Okay. And I think you've responded. I think I have the gist of your argument.
Okay.
Thank you. Thank you very much.
Yeah. Kind of part and parcel to what Judge Castawayo was just saying, that when the appellee says that the motion for rehearing that I filed in response to the judge's order on the case management conference, where the judge says, the new judge, and Judge Battles, who was a very good judge, probably my favorite in Hillsborough County, but he didn't have any knowledge as to what was actually happening in the case. He just said it's a foreclosure trial. The second DCA told me not to dismiss it. Therefore, I'm not going to dismiss it. And I argued in the motion for rehearing because I agree it wasn't procedurally proper, but I had nothing else to do. There was no pending motion for a new trial. Judge Battles just did that. So I had to get something on the record to say, look, we are advocating for a dismissal at this point. And what I said to Judge Battles in the motion for rehearing, and I cited again in both of my briefs, that you're applying the wrong standard. What the judge is doing is saying, well, if the second DCA on what you could say a quasi remand instruction, although there was no mandate and it was, on a concession of error and there was some other complications, but nonetheless, the second DCA did not tell me to dismiss it. Therefore, the default should be we go back to trial. That's not what this court said. Yes.
Mr. Frank, can I interject? Because this is a very unusual procedural posture of a case. My understanding is that ultimately, I guess the trial court decided to vacate the final judgment. And this is what's in the record. And then at that point, my understanding of the judge said, okay, I need help from both of you. What do I need to do? And so at that juncture, walk me through it. What steps did you take? Because I know they vacated the judgment. You're making the argument that it should all be dismissed in its entirety. And then what happened?
So the judgment's vacated by Judge Taylor. We have 3 separate case management conferences in which I advocate and cited in the record that it should be dismissed at every single one. The judge says, Judge Taylor says at the last case management conferences, I don't know what to do here. I want you guys to ask the DCA on my behalf what to do. And the District Court of Appeals said, we already told you what we wanted you to do.
Yeah, I think where the thing went off the rails is when our court received the concession of error. What we should have done is reverse the judgment below. You had requested in your brief reversal with direction to enter an involuntary dismissal. And that's what we should have done rather than remand for the lower court to vacate the judgment. And once, because once the court vacated the judgment, it still had a case pending. And you know, that's on us. I'm not sure whether we can correct that at this point. There you go. I mean,
Yeah, okay.
that at the second trial, the bank didn't prove up its case.
Sure. We had, I mean, that's the second part on appeal where and I guess I'll go into that, but the last thing I want to say on
We can reach back into that first case and fix it. Tell you the truth.
Well, I don't think you have to reach back into the first case, because even if this court could have done something different back in its order of that it's not even a remand, it's a temporary relinquishment of jurisdiction. And I don't know that it would have been better if the court would have instructed what to do, but they didn't. And the only way that the court can't fix it would be if this appeal is time barred. It can still fix it.
I don't think this appeal is time barred, to tell you the truth. I personally think that argument doesn't fly. So.
Okay. Well,
and I guess, Mr. Fregerson, I share what Judge Northcutt is saying, is the fact that what we should have done in the first appeal is to basically enter an involuntary dismissal in light of the concession of error. And that's what led me to ask that this is a very strange procedural process, how we got here. So the question is, at this point in time, I know what Mr. Gottlieb is arguing before the court, and I know what your position is, and you're taking the position this is a second bite of the apple. They shouldn't be allowed to do that. And so the question is, what is the remedy at this point in time?
I think if the rationale was going to be applied by this court as followed by Tracy, of course that controls it deals with remand instructions, but the same guiding principle should apply to the trial court. Regardless of who made the decision still should have ended in the same result, which would have been entry of an involuntary dismissal. So I think if the court looks at, well, whether or not we did it or Judge Battles did it in this case, while we weren't all the way wrong, we maybe weren't as clear as possible, but Judge Battles was. He says we're going to have a trial, and that was wrong. And I don't, procedurally, as this court's identified, it was impossible for us to identify that case management order as an appealable issue, considering the gap and the procedural irregularities that involved the vacating of the first trial. It was almost as if there was an appeal, but it was an appeal from Judge Taylor to the second DCA. I would like to touch briefly on the second part of my appeal, which is the issue of the
you reached that because you are now into your 7-minute rebuttal time, Mr. Fredericks.
Okay, I guess I'll just take 2 more minutes and then I will save the rest for rebuttal. But the issue was whether or not the admissibility of the original note. In this particular case, the note was entered as a self-authenticating document. The problem was the trial witness says that's not the note that we have. That note doesn't have, our notes don't have a third allonge. That one does. So then we go back to, well, what was the other evidence of standing at inception? If it was, if the witness says, the only witness says, that's not our business, we never had that note, we had something else in our records, but it wasn't that, then the only thing would be Ortiz. The problem in Ortiz, the problem with this particular case is the complaint was filed only with 2 allonges. 4 weeks after that, they filed a notice of filing original. It had 3 allonges. They admitted that document at trial, but that was 4 weeks after the trial started. There was 0 evidence of standing at inception, and I'd like to reserve the rest of my time for rebuttal. Thank you, Your Honors.
Great. You have about 6 minutes, Mr. Frederickson, for rebuttal. Okay, Mr. Gottlieb.
Good morning. May it please the court, Mark Gottlieb with Ackerman LLP on behalf of FLE, Federal National Mortgage Association. I guess I would just start with the point that was raised by Judge Castanueva and agree that this is an issue that should have been raised, that had an opportunity to have been raised twice, both when the court initially relinquished jurisdiction rather than issuing remand instructions and an instruction to dismiss. And then again, when it came back up to the court with Judge Taylor's order requesting clarification, with the request from appellant for a clarification, the court again declined, dismissed the appeal, and basically, punted this back to Judge Taylor in the lower court to decide what to do next. There was an opportunity there to have sought rehearing, sought a final determination from this court, and that wasn't done. That being said, having had this bounced back to the lower court for determination, it was placed in a procedure very similar to a 1.530 motion.
It wasn't a 1.530. That's the point.
I understand. It was not a 1.530 motion. I will say,
Even if it was, Mr. Gottlieb, even if you say, okay, it's reviewable under Rule 9.110, that doesn't make it a final order that has to be appealed at that time. If you look at Rule 9.110, the scope of the review from a final judgment, which this is anything that happens before the filing of the notice of appeal. So on an appeal from a final judgment, we can look at anything that happened up until the time that notice is filed.
not orders that are appealable as final orders under 9.1.
It doesn't say appealable as a final order. It says appealable according to the procedure under 9.110. There's no way an order granting a new trial meets the definition of final order. It just doesn't.
It doesn't, but it's treated as the functional equivalent of a final order for appellate purposes under 9.110.
All it says is you can do it according to the procedure under 9.110, or the method rather. It doesn't say it's a final order. But we're going to differ.
I'm not disagreeing with you that it's not a final order. I'm saying that the Florida rules treat it as the functional equivalent that mandate, the word is shall, appeal within 30 days or lose that ability. It's not something that you can come back at the end of a proceeding. That's our position on that. I think it's.
I get it. You and I are going to disagree, so probably ought to head on to the rest.
All right, then we'll move on to the rest then. We do believe that this was the functional equivalent that should have been appealed at that time. Notwithstanding that, we believe that the court properly exercised its discretion in the position that it was placed in deciding to grant a new trial request in this case. It came back to the judge with no instruction or direction, and after hearing extensive argument from the parties about what should happen next, the court ultimately made the decision not to dismiss and to proceed with a new trial. That comes clothed with the presumption of correctness. We've certainly cited the authority from this court that it's a very high bar standard for overturning a lower court decision to grant a new trial in this type of situation. That's Meadowbrook Meat versus Cantanella. Again, comes clothed with the presumption of correctness and won't be disturbed absent clear abuse of discretion. Appellant in this case makes no attempt to even argue that there was a clear abuse of discretion in granting a new trial. I think, as this court has itself noted in cases like Tracy and other cases, the decisions about granting of a new trial in foreclosure cases after an unsuccessful first trial are all over the map. I think it can hardly be argued that reasonable judges confronted with all the authority out there couldn't differ and come to a conclusion here that a new trial was appropriate in the exercise of their sound discretion. Again, if you read even the transcript of the hearing, Judge Taylor was faced with sort of a difficult choice, and then eventually Judge Battles, given the lack of instruction or direction from this court, including when it declined to reconsider that when requested by Judge Taylor, the court even questioned, why are there no instructions and why shouldn't I proceed? If there was an intent for me not to proceed, I would have been so directed by the appellate court. So we think the standard that governs here is Meadowbrook Meat, that it's a very high bar. There's just been no attempt to argue an abuse of discretion under that standard, and that it should rest with the court's decision to grant a new trial. I know that they have argued for the application of the standard in Tracy and Mace. We would argue that that doesn't apply here. that related to this court's adoption of a standard as to what it should do in issuing remand instructions, and that obviously didn't happen here. So again, under those tests, under those standards, we believe that the court's decision to proceed with a new trial should be affirmed and deemed to have been well within its discretion. With regard to the issue of standing, the arguments are a little bit all over the map, but I think ultimately they boil down to not an issue of lack of proof of standing, but an issue of challenging the court's decision to admit the note and allonge that were admitted into evidence at trial. So it's really just an admission of evidence argument on appeal, which is governed by the abuse of discretion standard. At trial, the court admitted a note with an allonge that bore two endorsements, one from the originating lender, JP Morgan Chase, to its servicing subsidiary, Chase Home Finance, all dated before the commencement of the foreclosure, and a second endorsement from Chase Home Finance in blank. That was admitted at trial. I will say over the objection, but really no objection was clearly elucidated at the time that the document was admitted, other than the fact that no trial should be occurring at all. The only argument being made as to why those shouldn't have been admitted is because there was testimony elicited from the witness that he didn't recognize those documents. He couldn't authenticate them from the documents he had reviewed in the file. But these were admitted and properly admitted as self-authenticating documents under 90.9028. A note, allonges, signatures thereon are all admissible as self-authenticating documents. And that's the premise on which they were admitted. The court did not abuse its discretion in applying 90.9028 to admit those documents. The fact that the witness said, I don't recognize them, I haven't seen them before, is ultimately irrelevant. No authentication from the witness was necessary. No witness was necessary to get that document into evidence. It certainly can't be said that the judge abused his discretion in putting that document into evidence and allowing it to be admitted under those circumstances. Once you get past that, there's no other argument that's being made for lack of proof of standing at trial. The only argument they make relates to the admission of this note with the allonge. They seem to concede that with the admission of the note, there is more than ample evidence of standing. You have the note with the dated endorsements, both of which predate the filing of the action. You had assignments of mortgage admitted without objection that really led to the exact same place in assignments from the originating lender, Chase Home Finance, and then to the substituted party, Fannie Mae, after the action was filed. So really, it just boils down to, was there an error in admitting this document? And I don't think that there's any close call here as to whether you can argue that the judge abused his discretion in applying 90.9028 and admitting the document. So for all of those reasons, we submit that the court's actions were proper and that the judgment entered on the retrial of this case should be affirmed. If there are no other questions, I will yield.
Thank you, Mr. Gottlieb. Okay, Mr. Frederickson, you have 6 minutes for rebuttal.
Thank you, Judge. What Mr. Gottlieb is suggesting is that Tracy and Mace are distinguishable because they involve remand instructions or constraints upon this court, and therefore they would not apply to a trial court. The implication being that the trial court result will be different than this court's result. It's going to be the same guiding principles, whether or not it comes from this court or it comes, and that's kind of what we're saying, whether or not it came from Judge Taylor or Judge Battles or this court. In a lot of ways, this is going to be the same guiding principles. It's not as if you would not follow Tracy if it did not involve remand instructions, because you could argue this case was similar to that. And at least, if you look at the attributes of the order and then how it actually came down. I want to briefly touch on Mr. Gottlieb's comments about the authentication. And even if Mr. Gottlieb is right, that the court did not abuse its discretion in admitting the note itself, there was not, all that would do is establish standing at the time of trial. It does nothing. It does nothing for standing at the time of inception. You could look towards Ortiz if the complaint was in the same condition as the note, and it wasn't. Or you could look towards testimony of the witness. Yes, we had this at the time of inception. The witness says the exact opposite. That's not what we have. We have something different. That's the closest they get to standing at inception in this particular case, or the filing of the notice of filing originals that the court, I guess, took judicial notice of in kind of some bizarre, kind of strange procedural thing. But nonetheless, that would have been 4 weeks after the filing of the lawsuit. I guess I want to go back to the first issue, which whether or not, how do you fix it? How do you fix the issue of perhaps this court's error? The error did not really be, although looking back on it, hindsight being 2020, it wasn't, I think it was an error, or at least lack of clarity. But for all intents and purposes, we as the litigants asked the court, what else we're gonna do a motion for rehearing, which was similar, even from the court said, hey, I need help here. We don't know what you want us to do. Now, we weren't advocating for one side or the other at that particular time, but the judge was asking this court, and this court refused. I don't know if it would have been any different on a motion for rehearing as to an error that had not yet occurred yet. I could see, like, well, Johnny Carnac says that if we would have asked before that would have happened, it might have been, if the trial judge does this, then come back to us. I'm not saying that's what you would have done, but I certainly could have seen that happen. So it would have been required for us to appeal that or challenge this court's ruling as to the remand instructions. It would have required forethought that's impossible, and looking into the future as to what was going to happen, because we had a 3-month break, 5-month break in between those two orders. So I have nothing further, and I'd like to field any questions if this panel has any.